is Scott Hemingway. I've been practicing intellectual property law here in the Dallas Fort Worth area since 1991. So I've been practicing approximately 33 years. Our firm handles both prosecution, which is filing of intellectual property rights and obtaining those rights with the proper government agency, as well as litigation or dispute resolution. And that's when somebody has an intellectual property right and they want to enforce it. We would represent that party, or we would represent the defendant or the accused infringer. So we represent parties in both prosecution, which is the interactions with the government agencies to get the rights, and we represent litigants or dispute participants as far as enforcement or defense of against accusations. I'll be covering the major issues or the major types of intellectual property that are out there. If you think about intellectual property as an intangible asset of a business or an entity, if you take any business and you strip away the building, the physical assets, and you strip away the employees, usually what you're left with is the intangible rights, which are patents, copyrights, trademarks. And if you have some key employees, or if you have some employees that are under contractual obligations, then you have a certain number of types of intellectual property protections that are governed by contract law. And I'll go through those at the end of the presentation. The major issues as far as intellectual property rights in these categories is patents, which cover new ideas. These are new innovations, and they can cover methods, they can cover compositions, they can cover devices. These are systems. Predominantly what we're talking about here is a new and better way of doing something. It's a new and better mousetrap, as if you will, but it's got to be something that's a new and an improved version of whatever's been done in the past. It can't be something that's been out there for a number of years. And we'll talk about some of the timing aspects later. But newness and novelty are a big issue with patents. Trademarks are generally going to protect your brands as far as your company names, your product names, slogans, taglines. Logos are protectable as far as trademarks are concerned, as well as words. Copyrights are going to talk, we're going to talk a little bit about what that protects, but bottom line is you're talking about some type of artistic expression, some type of expression that is not an idea, but it is how you would express that idea. And copyrights span a wide spectrum in our normal everyday life. If you think about paintings, theater, movies, music, these are all artistic expressions. They're all protected by copyrights. And it's a much narrower right because it's going to protect an expression of an idea, not the idea itself. And there are some aspects of copyright law that we'll touch on your practice or most businesses. And then there's the agreements that I'll talk about toward the end of the presentation. Okay, so as far as current events on patents are concerned, you've probably heard quite a bit about the Ozempic weight loss drugs. There's also in less recent past, probably 20 years ago or so, Viagra pills came out with Pfizer's blue pill. The patent aspects of this involve the composition, that is the drug itself. And the whole idea behind patents is that people invest a lot of money to develop these new compositions or new systems or new devices. And the patent laws will protect their right to recoup that research and development investment of time, money, and effort that's been spent to develop these products. The patents will come in and give a limited proprietary rights so that the person that invests that money can recoup that investment, hopefully make a profit, and the thought is that they will reinvest that profit into other innovations. So in essence, what the patent law is protecting is a party's right to invest, develop, recoup, and then reinvest. And hopefully we keep a momentum and the incentives alive to research and develop new and better ways of doing things in this manner. So that's the whole idea behind patents. But at some point, the patents do expire, and that's where you get the generic drugs that come onto market. And then there's also the FTC is they've recently come out with what they called a junk patent listing, where, for instance, the Novo Nordisk has been filing certain patents on injection devices and things. Now, the injection devices they're talking about it's one of many on a list that the FTC has come up with, but it's basically a spring-loaded injection device. And the FTC has come in and said they're not too sure about this, and they've developed a list of what they call junk patents, which they're not sure about the motive and the intent behind Novo Nordisk's, but they may be trying to extend their patent right beyond what it would normally expire at, and they do it by protecting the injection device or some other type of auxiliary or ancillary device. As far as your practice is concerned, again, you can talk about new methods of operation, new procedures, new devices, new compositions. It's not just drugs, it's devices as well. And even there's a recent patent that was issued regarding TAVR catheters, and there's quite a bit of technology being patented in the last few years regarding TAVR. In this slide, it's talking about a catheter on a particular part of the heart, and it shows basically the last couple of figures is where the device how it's being used and what it's being used. One of the requirements of patents is that you tell the public in the patent the best way of using the device and enabling them to use it. So when it does become public, that the public should be able to look at the patent and acquire that knowledge. One group of patents that we've been involved with is there was a gentleman, Gordon Dorn, who's patented all the way back into the mid-70s, and he was with Wadley Research here in Dallas, Wadley Technology. I think it became the Carter Blood Center and Foundation. Then he was patenting devices or these. He focused his efforts quite a bit on stabilizing samples, either urine or blood samples or other types of samples, and the stabilization of those samples was important so that they could be tested after certain periods of time when they would normally not be able to be tested. So this is a really good example of an asset that is developed by a practitioner or a researcher and how it can end up benefiting their life. He sold these at least some of his technology over to Becton Dickinson, and received quite a bit of royalties from these types of stabilization patents. And even when he retired, he received royalties long into his life, and then even after he passed away, his estate and his widow was receiving royalties, I'd say 5, 10 years after he passed away. So these are long-term assets. These can be very important, and they also can be very beneficial to your personal asset base as well as the practice asset base, especially if the practice is going through some type of monetization event where you're selling the practice, or it's maybe you're retiring and you're wanting to sell the practice, or if you want to license the technology off to some type of pharmaceutical company or other type of supplier. Just some issues that come up with patents. There are bar dates, which means there's timing issues involved with patents. The novelty issue, the newness that's required for patents is embodied in the law. So in the United States, from a public disclosure of your invention, either at some type of seminar or in a medical journal or in some type of sale document where you're out there advertising it, from that kind of what's called a public disclosure date, you have 1 year to get on file with your United States patent. And that's a requirement because the patent law wants only new inventions to be filed on and protected. And the patent law is basically set here in the United States that if you file on something that's more than a year old, it's not new anymore. Okay. The foreign protection that you might be able to obtain from some foreign countries, they don't even give you that year. There are most of the countries overseas and outside the United States are what are called absolute novelty bars, which means you can't be out in the public domain for 1 day before your filing date. So that's why we recommend for the most conservative approach that you apply for your patent rights here in the United States or through some international treaty, which there is a international patent cooperation treaty that you can file for foreign protection, but you get that on file before you ever disclose it to the public. So it's an important timing aspect. It gives you the most flexibility when it comes to foreign filings, and that allows you the best possible aspects as far as protecting your patent rights here in the United States and overseas. So you can and often do get patents in foreign countries as well as domestic countries. You want to think about manufacturing centers and sales centers as far as where you want to protect your patents. As the United States is one of the largest manufacturing centers as well as one of the largest sales areas in the world, then most people want to file in the United States, but there's also a lot of foreign countries that you want to consider as well. And those would be important for manufacturing or sales locations. We recommend prior art searches before we do any type of filing. Oftentimes that will give you a snapshot about what people have already patented. If it turns out from a prior art search that your device, your system, or your composition, whatever you got that you think is new, if it's already been patented, then we need to determine what possible distinctions or material differences are that may exist between your invention and what's already out there. And if there aren't any, then maybe that's a red light, green light issue. If there are substantial differences and those are marketable differences, then we need to focus the examiner's attention on those differences and not allow the analysis to get off track as far as the examination process. So if we focus on novelty issues, that is differences between what you do and what the prior art does, we have a much better chance of success at the patent office. So as far as timelines are concerned, from filing date to a determination on any particular application, the average timeline for that is about 2 years. Now, for more crowded fields and areas of technology, for instance, cellular technology, microchips, electronics, medical devices might be in that category. It's going to take longer. And for less crowded fields like barbecue equipment or water sprinklers or something like that, it's going to take less time than that. But the average timelines that are given by the patent office, the pendency of any particular application is about 24.5 months. So that's it's a year-based process. It doesn't happen quickly. That's why you need to get going on your application process well ahead of any time frames that you have as far as your business or your practice are concerned. Budgets, for a utility filing, you're probably talking, and that's what I've been talking about mostly here, is a utility patent application filing. Your budgets are going to be between $10,000 to $20,000 to get on file with the application at the Patent and Trademark Office, and that's probably about half of your total all-in costs. So just be aware that these are expensive. They take years to get, but they can benefit you significantly over the course of your life and even after you pass away. I'll just put a postscript that there's also design patents that are available to you. These are not going to protect functional aspects of your whatever device you've got or whatever you're trying to protect as far as the design is concerned. These are going to protect the way the whatever device looks like. Now, we've been involved with quite a bit of design patents on like tire treads and shoe insoles. In fact, we represented Spinco Medical down in Waco for a number of years, and we had hundreds and hundreds of design patents on their insole devices. And the good thing about that is that we could file both utility cases on how the insole functions, as well as design patents on how it looks. The design patent would only protect the ornamental aspect of the insole. The design would not protect how it functions. The utility case, the utility patent application would protect how it functions, what it does, the utility of the insole. So, but I did want to mention that sometimes design patents are pretty useful. Okay, trademarks. We're talking about protecting brands here. So obviously there's some major brand medical centers, hospitals that are in the area. You're talking about Southwest Western Medical, Texas Health Resources, Baylor Scott and White. These are all trademark logos that are associated with their particular service or their location. Also, drug companies, Pfizer, they even put it on their blue pill. Now, they've had trouble trademarking the shape, especially in certain countries, of that blue pill, but that does not prevent them from protecting the actual name and how they present it. And what you're trying to protect is either company name or product names. And you're wanting to protect both the consumer as well as your source of those services or those products. So in this instance, maybe it's McDonald's, and they don't want uh, uh, some type of restaurant opening next to a particular franchise that is called McDougal's, or and uses a single arch. So that's an example from an Eddie Murphy movie, but it is uh, applicable, showing that there's two groups of people that are wanting to protect this. One is that the company, McDonald's, will want to protect it, but there's also a protection of consumers, that you want to protect consumers from being confused and going to the wrong restaurant and getting something of less quality than they expected. So when we have brands like UT Southwestern or Baylor Scott and White, Texas Health, they have these brands, and consumers will associate a particular level of service that's associated with those brands. And if they see something that's similar to it next door or down the street or on the internet somewhere, and it causes them confusion, then there's two parties that get hurt. One is the UT Southwestern group, and also the consumer is hurt because they're getting some service that is maybe substandard or different than what they expected. Here's some trademarks. These are logo marks on different practice groups here in the Dallas-Fort Worth area. Dallas ENT Group. There's a cardiovascular group, and in the middle, and there's Heart Place, U.S. Heart and Vascular. These are all logo marks, but they could equally protect the word marks as well. So, and that's just some general aspects of trademarks, is that you can protect the logo. That is, for instance, the McDonald's arches, or how McDonald's is typed out in the certain font or colors. That's their logo. And then, but the word McDonald's can also be protected as a word mark, and that can equally have rights no matter how it's presented in whatever logo or font style. You can file for your application with the United States Patent and Trademark Office if you have an intent to use it, or if you are in actual use of it. Before you will get your any registrations on an intent to use mark, you'll have to show actual use in commerce. But you can get the application process started earlier than that and get it examined by the trademark office and the trademark examiner to see if you're entitled to get that right before you start use. But at some point before they issue a registration and put you on the principal register, they're going to want to see you are in actual use in commerce here in the United States. You can get both foreign trademarks in foreign countries, and you can get United States trademarks. You can get federal rights here at the United States Patent and Trademark Office, and you can also get state rights. Oftentimes, the state secretary of state's office will issue trademarks that are applicable just in your state. Now, I will always defer to the federal right first, because that gives you nationwide rights. But as a backup, as a secondary option, then if I can't get them at the federal level, then I often recommend at least getting them on the state level, and that helps you get at least some type of protection. And again, you want to think about where you're practicing, where your consumers are going to be located, and that will dictate usually in this instance, it would be your practice area, where geographically you're practicing. I often recommend trademark searches. Quite a bit for the same reasons as a patent search, but you want to find out if anybody has already trademarked your logo or your word that you want to get a trademark on. It can help you determine next steps in the process. Timelines, you're usually talking about 9 to 12 months from filing to some type of decision. And budgets to get on file, you're probably talking between 1,500 to 2,500 to get on file, and that would be about half of your all-in costs. So that's your budget, and let me move on to copyrights. So we're talking about artistic expression here, not ideas. So let me give you two different web pages, and let me compare and contrast these that are on the right-hand side of the screen. So on the right upper part of the there's a web page is Heart Place US Heart and Vascular, and it's got artistic expression there. You can see that it's got different photos. One's in a background, one's in a foreground off to the left here. You've got a model, and you also have some text here that's in a certain phrasing or expression. So we're talking about how artistically you're expressing yourself, and that's predominantly where the copyrights are going to come into play. So somebody produced a very similar artistic expression using a very similar model and similar expressions of words, then, and you had a copyright on this, then you can potentially take action and prevent that kind of use of your artistic expression. Now, what I'll compare that and contrast that with is there's also, for the same Heart Place, there's a portal for payment. Now, there's only a certain number of ways you're going to be able to express a portal for payment, either one-time payment or sign-in. Some of this expression is your text, and that is your literary expression and how you would express things. But there's less copyrightable subject matter in the bottom screen than the upper screen. And so that's important to understand and contrast with as far as understanding that your copyrightable expression goes with the higher level or the majority of your artistic expression. Photos, website content, forms are protectable, but in the same context of this payment portal, if it's expressing just an idea, it may not be protectable on copyright, but maybe it would as far as how it's expressed, or if there's artistic expression. But it's not just the idea of whatever you're trying to protect on your form. It's how it's expressed. Again, here's some more artistic expression in websites. It's also possible for an app through a graphical user interface to have some copyrightable subject matter. But so here's, artistic expression in the photos, and how this information is arranged, how it's expressed, but not necessarily in the idea of a website itself. General aspects of copyrights, we have the expressions are protected, not the idea. You'd protect them with the United States Copyright Office. There is foreign and domestic protection. Your timelines, you should be able to get some type of response back from the Copyright Office within 6 months or so. I very rarely had anything longer than that. And your budgets are probably to get on file is between 500 to 1,000, and that's on the high side. Oftentimes it'll take less than that, and that's most of your costs, but there might be an additional 50% on top of that to get all in as far as subsequent docketing and other filing costs that are involved with getting your copyright. Again, this is a narrower protection, so you're not spending as much money. But oftentimes, what I recommend is that every 6 months or year that you do an analysis of your websites and go ahead and file on your application. Because what will happen oftentimes is somebody will leave a practice and they'll go down the street, and then sure enough, their website will look a lot like your website. And what you want to have is some protection against somebody leaving practice, one of your practices, or doing something and setting up a website that causes some confusion, that causes some type of taking of your intellectual property, if you can avoid it. And if that happens, you want to have some teeth on any type of cease and desist letter. And copyrights, patents, trademarks are the teeth that would be used in those types of cease and desist letters. As far as contracts are concerned, there's non-disclosure agreements, there's non-solicitation agreements, and there's non-compete agreements. These are the three major types of agreements that you'll either be asked to sign yourself, or you'll ask one of your employees or one of your practice partners to sign on their behalf. Non-disclosure agreements are pretty self-explanatory. They agree that if you're signing it, you agree that you're getting some private, non-public information, that you're not going to disclose it or improperly use it. Usually there are timeframes involved, and that you're going to keep that information confidential and not disclose it. And again, you can ask other people in your practice, or other people may get asked to sign these types of agreements as well. Usually the timeframes are between 2 to 5 years, and they can be extendable from that timeframe. What you'll often find is non-disclosure agreements get signed when there's some type of practice transition or some type of business transition. When somebody's looking at the books or looking at the practice, and they're looking at potentially an acquisition, that you want to be able to disclose information without having fear that it's going to get posted on a website somewhere, or posted on Twitter, or on LinkedIn. As far as non-solicitation agreements, those agreements relate to your agreement, or whoever signing the agreement, their agreement not to solicit, for instance, clients or suppliers of the practice, or employees to your detriment. So if somebody signs this agreement and then they leave your practice, they agree, hey, listen, you're not going to contact my clients, my patients. You're not going to contact my suppliers. You're not going to contact my employees and try to get them to move practices over to your practice in the future. And as with non-disclosure agreements, there's usually a time frame involved. It's got to be fairly specific, and usually it's got to be to their detriment. And how the solicitation is agreed to not occur is usually needs to be as specific as possible and not ambiguous. Ambiguity with any of these agreements is not to your benefit, and it's really not to the other party's benefit either. The last category of contract agreements that are usually involved with some type of intellectual property or some type of intangible asset protection is a non-compete agreement. Here, ambiguity is usually the issue. And the FTC has just come out with a prohibition of all non-competes except for certain categories of salaried employees or high-level employees. They have a carve out on this prohibition, but bottom line is they've just come out with it. There's at least 2 cases that have contested it in the last, and this is just in the last 2 or 3 weeks that the FTC has issued their prohibition. And there's 2 cases that were filed within days of the prohibition getting issued. And they're both actually here in Texas. So I'm sure there's other cases that have been filed elsewhere since then. I'm not right now aware of them, but I know of at least 2 here in the state of Texas that have been filed. Usually non-competes have to be fairly clear and unambiguous as far as scope of what you're agreeing not to compete with, the scope of the activities, geographic scope, and time. So there's activities, time, and geographic region. And but I've read a lot of non-competes that are ambiguous, and you do not know what in the world you're being prevented from doing. The ambiguity is a real issue in these types of agreements, and it does have a chilling impact on your ability to move and practice in your area and use the skills that you developed in your life. So that's one of the areas that the FTC has really honed in on. In fact, I think they mentioned in the medical practice that non-competes have been used to create a real chilling impact on the ability of practitioners to move, practice their skills, and have some type of mobility in their practice. So that's pretty much it for intellectual property. Again, I focus mainly on these major aspects: patent, trademark, copyrights, and then the agreements. I also focus primarily on acquisition of rights. Litigation of any of these rights or dispute resolution is probably beyond the scope of this particular talk, but that's something we handle, and we can walk through those areas and aspects as well. Please contact me. I think that's pretty much it. I'm not even sure what the timing is on this, but hopeful that we're just about got the thumbs up on that. So thank you for your time. I appreciate it. Please give me a call or get in touch with me if you have any questions. Happy to address anything that I've mentioned here, or to address any follow-up that you may have. Thank you very much.